Okay, so today I'm going to be talking about the recent judgment by Judge Tolmay in the case of the Organisation Undoing Tax Abuse, also known as OTA, and the South African Pilots Association, SAPA, who are both the plaintiffs in a matter that they brought against Dudu Myeni and others, and that's become known as the Myeni judgment. Now, this is not the first time that a court has had to deal with a matter where a individual has been brought to court to be declared a delinquent director. But what is interesting about this matter is that it is a convergence of a number of director roles in a company, which the court considered, and then the court clarified these different roles and went on to restate the law in relation to these different roles and to make the ultimate court ruling. So the roles which the court addressed relating to was specifically that of a non-executive director, who is the chairperson of a board, and that of a non-executive director who's the chairperson of the board of a state-owned entity. So the facts of this matter briefly were that OTA and SAPA sought an order declaring Ms. Myeni, who was the former non-executive chairperson of SAA, to be declared a delinquent director in terms of Section 162, subsection 5 of the Companies Act. And the history surrounding her appointment as a non-executive director were briefly that she was initially appointed as a non-executive director to the SAA board in September 2009. She became its acting chairperson in December 2012, was appointed chairperson in January 2015, and was reappointed chairperson in September 2016, where she served until 2017. She was also a member of the Accounting Authority of SAA, as contemplated in terms of the Public Finance Management Act, because SAA is listed as a major public entity in terms of Schedule 2 of the PFMA, and its board is the designated accounting authority in terms of Section 49(2)(a) of the PFMA. Now, Section 162 of the Companies Act provides that a number of interested persons may apply to court for an order to declare a director delinquent. Those interested parties are a company, a shareholder, a director, the company secretary or prescribed officer of the company, or a registered trade union that represents employees of the company, or any other representative of the employees of that company. They may apply to declare a director delinquent if that person is currently a director, or within 24 months immediately preceding that application was a director of the company, and inter alia, that director has consented to serve as a director whilst ineligible or disqualified, or whilst under probation, and has also grossly abused the position of a director, intentionally or by gross negligence inflicted harm upon the company or a subsidiary of the company, contrary to the provisions of the Act, or acted in a manner that amounts to gross negligence, willful misconduct, or breach of trust in relation to the performance of such director's duties. Now, Section 162(5) of the Act goes on to specify that a declaration of delinquency has the effect that a person may not serve as a director of a company for a minimum of 7 years or such an extended period as decreed by the courts. Now, our courts have already pronounced on the issues of delinquencies, and that is a matter of stated law. So the SCA has previously in 2017 stated the law as follows, that Section 162 has a protective purpose, namely to ensure that those who invest in a company, whether big or small, are protected against directors who engage in serious misconduct of the type described in these sections. That is, conduct that breaches the bond of trust that shareholders have in the people they appoint to the board of directors. Directors who show themselves unworthy of that trust are declared delinquent and excluded from the office of directors. It protects those who deal with companies by seeking to ensure that the management of those companies is in fit hands, and it is required in the public interest that those who enjoy the benefit of incorporation and limited liability should not abuse their positions. The SCA also went on to hold that a determination of delinquency can only be made in cases of serious misconduct, and the 4 grounds of delinquency set out in section 162(5)(c all share the common feature that involve serious misconduct on the part of the director. What it also found is that once serious misconduct has been established, a court has absolutely no discretion on whether or not to declare a director delinquent. It is bound to do so. The only discretion a court has is in relation to the conditions that it attaches to that declaration of delinquency in relation to the extent of the period of delinquency or any of the other conditions. So on behalf of the plaintiffs, OTA and SAPA, it was argued that Ms. Myeni's alleged conduct, sorry, just give me 1 second because there's a bit of noise in the background and I'm going to get rid of it. Apologies. This is the joys of Zooming from home, working from home, guys. I was talking about the argument that was advanced on behalf of the plaintiffs in alleging that Ms. Myeni's conduct was that of a delinquent director. And they argued that her conduct and failures during her tenure as both the director and the chairperson of SAA, the board of the SAA between 2015 and 2017, constituted willful and grossly negligent breaches of her fiduciary duties in terms of Section 76 of the Companies Act, read with Section 162(5)(c) of the Companies Act, as well as Sections 50, 51, and 55 of the PFMA. And even though they initially launched the action based on 4 transactions, for the sake of brevity and to get through all of the evidence within the limited time that they had, they only centered their case around just 2 transactions. And these transactions were known as the Emirates deal and the air swap transaction. And in these 2, the plaintiffs alleged that Ms. Myeni, through various acts and omissions, had frustrated the implementation of and took steps to ensure that the Emirates deal, which had substantial economic benefits for SAA, fell through. And although the Airbus swap transaction was eventually concluded, the plaintiffs alleged that Ms. Myeni's conduct leading up to the implementation of that transaction fell short of the conduct expected of a director and chairperson of the board of SAA. What the court found when it considered the evidence was that the evidence had clearly indicated that Ms. Myeni's obstruction and delay of the Airbus swap transaction was clear and proven, and that as chairperson of the board, she did not show any concern for the catastrophic consequences of her actions, not only for SAA, but for the country. The court also found on the evidence that Ms. Myeni's conduct in blocking the Emirates deal satisfied the multiple grounds of delinquency, which were set out in Section 162, subsection 5(c) of the Act. Not only did she deliberately or through gross negligence inflict substantial harm on SAA, but her belated attempts to justify her conduct showed that she acted dishonestly, in bad faith, and not in the best interest of SAA or the company. So that's just a very brief summation of the outcome of the evidence in relation to just the 2 cases that they dealt with. Now, there were a number of sub-issues that arose, and one related to locus standi, which is the standing of the parties to bring the action. And it's apparent that OTA does not fall within one of the categories of interested parties which may bring, or which is empowered to bring the application in terms of Section 162 of the Act, in that it is not a shareholder, director, company secretary, or prescribed officer of the company, nor is it a registered trade union. So this issue was taken up by Ms. Myeni in a separate side interlocutory application when she challenged their locus standi to bring this action against her. And in that separate application, the court ruled that OTA did actually qualify to bring the application, but it qualified in terms of a separate section, namely Section 157, 1D of the Act. And in terms of that section, the Act allows any person to exercise any of the remedies set out in the Act when they are acting in the public interest and with the leave of the court. So they were allowed to remain as a plaintiff in the matter. In addition, what the court also found was that it was certainly not disputed that SAPA was clearly had locus standi to remain a plaintiff in the matter. The second sort of subset of issues that arose was the fact that Ms. Myeni took issue with the fact that she was the only director that was targeted by the plaintiffs, when she, notwithstanding the fact that she was the chairperson of the board, there were other directors on that board as well. And in this regard, the court briefly went through the issues relating to a board versus a single director, and it restated the law in that regard as well. And it basically clarified that Section 66 of the Companies Act provides that the board has collective and ultimate responsibility for the functioning and day-to-day management of the company. And the board is accountable for its performance, but individual directors also owe the company certain obligations and duties in their performance of their functions, both as executive and non-executive directors. So the collective responsibility of the board imposes individual duties on the directors. And the directors are still obliged to comply with their fiduciary duties imposed by Section 76(2) and 76(3) of the Companies Act, failing which they can be held jointly and severally liable for any wrongdoing. So in response to the fact that she was targeted as the sole director in this action, the court found that in dismissing that application, the court found that the relief claimed against her did not impact the other directors directly, because they did not have a direct and substantial interest in this matter, because there was no relief sought against them. There was no declaration of delinquency against them personally. In addition, the court found that a director cannot avoid individual liability by blaming the so-called collective. The fact that I'm part of a board of directors, therefore the collective is responsible for the decision-making. Also notably, the other directors may still be brought to court by any other interested parties on a similar or the same set of facts at any date in the near future. On the issue of non-executive directors, the court simply restated the existing legal principles as they exist in our law, which was stated in a 1991 appellate division decision, which is that being a non-executive director does not absolve a person of any legal responsibility. The legal duties of all directors are the same, namely the duties of care, skill, and diligence. Compliance with these duties requires an assessment of the role actually played by the director, the information available to her, and the information that could have been available. In considering the powers executed by the non-executive directors, it is clearly appropriate that there must be no distinction drawn between the role of executive or non-executive director. Then the court went on to consider the duties in terms of the Companies Act, and set it out in terms of basically that the fiduciary duties are owed by a director to the company and are clearly spelled out in terms of Section 76(2) and 3 of the Act. 76(2)(a) states that a director must not use her position or any information obtained while acting in the capacity of a director to gain any advantage for herself or for any person other than the company, or to knowingly cause harm to the company. Furthermore, Section 76(3) states that a director, when acting in that capacity, must exercise her powers and perform her functions in good faith and for a proper purpose and in the best interest of the company. When a director breaches these fiduciary duties or there is serious misconduct by the director, then an interested party may apply to court for an order declaring that director to be a delinquent director in terms of Section 1625 of the Act. The court also considered the King Code, but in this regard, it considered the provisions of the King Code 3 and not King Code 4. The reason for this is because the provisions of the King Code 3 were the provisions that were applicable during the periods of Ms. Myeni's tenure as a director and as the chairperson. Therefore, this was the code that was applicable to her. And in terms of King Code 3, the primary role of a chairperson of a board is to provide leadership to the board, set the ethical tone for its performance, and undertake the management thereof. The chair ensures that focus is maintained by the board on what is best for the organization, and the board conducts itself in a way that cultivates and exhibits the characteristics of integrity, competence, responsibility, accountability, fairness, and transparency. Another reason why the court considered the King Code was because it was apparent from the various compacts that SAA had concluded that the King Code was one of those that it considered itself to be bound by as a good corporate citizen. In addition, when considering the PFMA, the court found that the fiduciary duties entrenched in the Companies Act overlap with those contained in the PFMA with regard to major public entities. SAA is listed as a major public entity in terms of Schedule 2 of the PFMA, and its board is the designated accounting authority in terms of Section 49(2)(a). All members of an accounting authority are subject to heightened fiduciary duties when compared to those entrenched in the Companies Act. Section 50 of the PFMA states that the directors must, among other things, act with fidelity, honesty, integrity, and in the best interest of the public entity, disclose to the Minister of Finance all material facts, including those reasonably discoverable, which may in any way influence the decisions or actions of the minister, and prevent any prejudice to the financial interest of the state. Section 51 and 55 also set out further responsibilities of the accounting authority. Now, with regard to the PFMA and these particular sections, in the Airbus swap transaction, notwithstanding the fact that the minister had directed the board to conclude the transaction by the 21st of December 2015, Ms. Myeni had made no attempt to convene a meeting for this purpose in order to ratify the signatories, but fortunately, the Treasury had managed to secure the necessary ratifications by December 2015. The court also went on to deal with other instances based on the evidence that related to the actions and omissions directly of Ms. Myeni that impacted on Section 51, 50, and 55 of the PFMA. Before it found that she was not only untruthful, but that her actions had failed to disclose material facts which were relevant, directly relevant to the minister's decisions, this being in direct breach of her fiduciary duties under Section 51B and C of the PFMA, and in delaying the conclusion of the swap transaction, the court found that she had willfully and recklessly contributed to SAA breaching its financial reporting obligations under Section 51 and 55 of the PFMA. And then by attempting to renegotiate the existing transaction, her renegotiation attempts were an indication of an intentional or grossly negligent breach of her fiduciary duties, particularly because she didn't have any board resolutions or authorizations authorizing her to do what she did. The PFMA also goes on at section 86.2 to state that the board or director is guilty of an offence and liable on conviction to a fine or imprisonment of up to 5 years if that board or director willfully or in a grossly negligent way fails to comply with the provision of section 50, 51, or 55 of the PFMA. So ultimately, the court's findings were that Mr. Myeni did not exercise the ethical and effective leadership required by the Companies Act, King Code 3, or the PFMA. Not only was she found to have deliberately or through gross negligence have inflicted substantial harm on SAA, but her attempts to justify her conduct show that she acted dishonestly, in bad faith, and not in the best interest of SAA or the country, and that this led the court to the inevitable conclusion that she had breached her fiduciary duties to act in good faith for a proper purpose and in the best interest of SAA in terms of 76.3 of the Companies Act. It also found that she had acted dishonestly in bad faith, and she had deliberately or through gross negligence inflicted substantial harm on SAA. She was found not to have acted as a reasonable director would. The court described her as a director gone rogue who did not have the slightest consideration for her fiduciary duty to SAA. And then it went on to declare her to be a delinquent director in terms of section 1625 for the remainder of her lifetime. In addition, a punitive cost order was made against her, and the judgment and evidence was referred to the National Prosecuting Authority for it to consider and determine whether there should be investigation for potential criminal conduct. It is, however, to be noted that notwithstanding this lifelong declaration of delinquency, Mr. Myeni is entitled after a period of 3 years to apply for the suspension of that order in terms of section 162, subsection 11 and 12, provided she can show that she has been sufficiently remediated and rehabilitated in terms of her conduct. It is also important to note, and this is also reflected in the judgment, that before the finding of delinquency was made, the court did take into consideration what is known as the business judgment rule. Since both the role of a director, whether executive or non-executive, is a critical role for a company and the economy to succeed, particularly since business involves taking risk and reward, and it's the director who is the individual that is at the coalface of making those decisions and considering the risk and reward. The business judgment rule is a defense that can be used for liability for actions that are taken bona fide and in the best interest of the company. This rule is basically set out in subsection 76.4 and 76.5 of the Companies Act. In order for a director to avail itself of the protections afforded by this rule, a director must ensure that they fall within the scope of the rule by being reasonably informed, not having material personal financial interest in the subject matter of discussion, and by having a rational basis for any decisions that are taken. So this business judgment rule can only protect those who act in good faith and have taken diligent steps to become informed. Willful misconduct, recklessness, and dishonesty are not protected at all by the business judgment rule. So ultimately, the key takeaways for directors from this judgment, in the consideration of all the issues that it did, are the following 6 key takeaways. The first is that the board bears full responsibility for functioning and management of the company, and it's ultimately accountable for the performance of the company. Secondly, non-executive directors are not absolved from any fiduciary duties in terms of the Companies Act. Thirdly, in terms of the business judgment rule, a director could be protected from an allegation of breach of her duties where that director took reasonably diligent steps to become informed about the matter, had no conflict of interest in relation to the matter, and had a rational basis for believing and did believe that her decision was in the best interest of the company. Fourthly, directors may be held jointly and severally liable for decisions taken by the collective. And fifth, with regards to state-owned entities, directors must keep in mind that the duties described in the PFMA do not exclude the provisions of the Companies Act, but must rather be seen as supplementing the overarching provisions of the Companies Act. And lastly, once a court has found that the grounds for a delinquency order have been established, a court has absolutely no discretion in this regard, and it must declare that the director is delinquent. The only discretion a court has is in relation to the period of the delinquency, and a declaration of delinquency can subsist for a minimum of 7 years and a maximum of a lifetime of the director, subject to the court's power to relax this order after 3 years only. So those are my key takeaways. And now we can discuss it. So feel free to put anything up on the chat, or you can unmute and we can chat. Because I know there's been a lot of, there have been a lot of opinion pieces that have been written about this judgment. And some have been concerned. Some have said that there was part of the judgment towards the end where the judge makes the point that when you're a director of a state-owned entity, there's a heightened fiduciary duty on you. And the argument has been made that, is this not changing the scope of the duties of a director? And I don't believe it does, because those comments were made towards the end of the judgment. They don't form part of it. That is what is called part of the obiter views of the judge. So it's not the actual judgment, it's her in addition views. It doesn't change the fact that the law is the law. The fiduciary duties are set out in the Companies Act and in the PFMA. She simply applied them as they were. What should also be noted is that Ms. Myeni has applied for leave to appeal this judgment. So the outcome of that will be, we'll see the outcome of that. But what happens with an appeal? This was not an application, this was an action, meaning that evidence was actually led over a period of time. And the evidence in this matter for the plaintiffs was 4 witnesses. So the various acting CEOs and CFO, etc. So it was quite a few people that led evidence. And for the defense, it was just Ms. Myeni who led her evidence. In addition, she was, the court took adverse views of the fact that she was not even present at the time when the plaintiff's witnesses were giving their evidence. So what generally happens when matters are taken on appeal, the court considers the evidence, but when it looks at the credibility findings, and credibility findings are when a court says things about the demeanors of witnesses, and in this case, this judgment is replete with credibility findings that are all adverse to Ms. Myeni, where it says she acted dishonestly and recklessly and with willful disregard throughout the judgment. An appeal court is loath, and very, very rarely does it overturn credibility findings, because the rule is that an appeal court does not have the benefit of the court hearing the matter to actually assess the demeanor of the witnesses. So it can't generally overturn a credibility finding. It will overturn findings of fact. It will overturn overturn findings of law. It will overturn findings of the application of facts to the law. But very, very rarely does it actually overturn findings in relation to the context of credibility. And most of this judgment was based on the credibility of Ms. Myeni and applying her credibility and her evidence, the factual evidence as it was, and applying that to the law in order to come to the basis of saying that she clearly had not behaved in accordance with her fiduciary duties as set out in either the Companies Act or the PFMA, and therefore the test had been satisfied to declare her delinquent. So applying those facts to the law, that's how you get to the delinquency. So whether or not she'll be successful remains to be seen. Unless you
Hi,
find...
Miss.
Yes.
Hi, Miss Nichols. Thank you so much. That's great information you're sharing with us. It's making us even more scared, I think, at least me, to be in a board. But what I wanted to ask is, okay, they did establish that, one individual board member has that responsibility, fiduciary responsibilities and all that in coming to the ruling. But did they have to establish that the other members could have perhaps not agreed with her in certain decisions that she ultimately made, or in certain actions that she ultimately got the, people to do, like when she stopped the Emirates thingy? Did they have to show that she actually did, the other board members were against what she wanted to do? Or was that not necessary because there was no delinquency charge against them?
Yeah, they weren't assessing the conduct of the other board members. They were only dealing with her. But they do talk about the other board members throughout. And the other board members either agreed with her or were complicit, or didn't do enough to challenge her or stop her. The only people who were challenging her and objecting to her actions were the plaintiff's witnesses. And they were all eventually fired or resigned. So that comes up in the judgment, that those who did challenge her were suspended or fired or resigned ultimately. But by the time all of this was taking place, there were only 4 board members left, which gives the impression that previous board members, this is not addressed in the judgment, but that previous board members must have resigned. But there were only 4 board members. 4 board members appear to have all been in agreement with her actions, because they are mentioned throughout the judgment and do appear to have agreed with everything that she said and did. Which is why the judge does go on to say that there's no reason why those board members can't be the subject of an application in terms of section 1625 by any other interested party, either on the same set of facts, because they were implicated.
Okay, yeah.
But she was judged on her actions.
Okay, all right.
So
yeah, thanks. It does seem a bit unfair because she might have acted with more power, but obviously those other ones, they were there, they supported her, and they should also at least face the same consequences, and not necessarily wait for somebody to come and complain. Like, she was the chairman, of course, but they still should face the wrath of the law for not doing anything, or at least for supporting things that brought the corporation down.
Well, that's a good point, and it won't just be that they should face it for just supporting. I mean, it's a bit more than supporting. They also, if one applies section 76(3), actually, and also the PFMA, they also didn't comply with their fiduciary obligations. But one of the arguments in the application in which she brought, where she argued, why am I the only one that's been targeted here? One of the points that was made was that a plaintiff is entitled to choose its defendants. So when you are a plaintiff in a matter and you've got 3 people that you can sue, all of whom are jointly and severally liable for your loss, you can choose who it is that you want to go after. You can go after all of them or just one of them. And in this case, the plaintiff chose to go after her for one of the reasons being financial. They couldn't afford to go after all 4 of those board members. It was 4 at the time, because they didn't have the finances, because OTA is an NGO. So it didn't have the finances to do that. So it took them, this matter is a 2017 case. So it took them from 2017 to 2020 to get the judgment, to get the matter finalized. If they had other defendants, this wouldn't have been finalized by now. So they chose one person and they chose 4 transactions, but even then, in the interest of finalizing the matter, they reduced the evidence just in relation to 2 transactions to support their allegations, to get it finalized. So it doesn't mean that any other interested person can't now go after the other board members, because OTA just chose one for financial reasons, because that was all that they could afford to do. Other than that, it would have been a month-long trial, which finances permitting and all the rest. And legally, they're entitled to choose who they want as a defendant. She could have likewise joined them.
Okay, thank you.
Hello, Trudie.
Yes.
Oh, thank you very much. As you have precisely indicated that in terms of the Companies Act, a court can declare the director delinquent for 7 years or for a lifetime.
Yes.
I'm going through this and I've been following the story of Dudu Myeni, and also reading, there are quite a number of articles you might be aware that are written by Rihanna Cassin on the issue of delinquency of directors, and specifically in relation to this, outside the case of Gihalwa versus Grancy Properties, which was at the Supreme Court of Appeal. Here, I've learned what the appellant contended that Section 162(5)(c) of the Companies Act was unconstitutional. I'll leave the issue of retrospective application, but my main interest is on the issue where he said there's no discretion vested in court to refuse or to make the delinquency moderate or less than 7 years. So if maybe I can get your comment on that one. Thank you.
Well, firstly, you know, until it's declared unconstitutional, it's not. So the law is as it stands. So because the Jawala matter is an SCA judgment, it binds all the lower courts. So Tolma had no discretion in that regard. She's bound by the SCA judgment, and that's the judgment that she referred to in the matter as well. It's binding. And it makes it clear that there is no discretion. So we have 2 pieces. We have the SCA judgment, which is binding on the lower courts, and we have the Act, which is clear as well. So the courts have no discretion. You have to, if you find on the evidence that it establishes what is set out in Section 1625(c), which is grossly negligent, etc., then you are bound to declare the person a delinquent director, and you must impose that for a minimum of 7 years. However, you go to Section 162(11) and 12, and there it says, after a period of 3 years, so even if the minimum is imposed, so a person is declared a delinquent director for 7 years, not a lifetime, after 3 years, that person can now apply to court and say, I would like to have my declaration of delinquency, which was imposed for 7 years, suspended or lifted, because I can show that in these 3 years, and let's say you don't bring it on the 3rd year exactly, you bring it in 3.5 years. In the last 3.5 years, I have remedied my misconduct in that I have done X, Y, and Z. I've gone on all these various ethics courses. I see where I went wrong. I did not make sure that I was always up to date and informed about matters. I allowed myself to be swayed. I wasn't prepared when I went into meetings, etc., and you are allowed to persuade the court that whatever led to your being declared a delinquent would not happen again. So that is a saver in Section 162(11) and 12, that you can, after 3 years, apply to have that uplifted. Of course, 7 years versus a lifetime, if you apply after 3 years to have a declaration that was imposed for a lifetime uplifted, I mean, I think it's unlikely that's going to be successful. But if it's a 7-year ban, then more likely you might be successful.
Thank you.
Trudie, it's Nandi.
Hi, Nandi.
I just want to find out, if you sit on a board that is so politically influenced, how do you protect yourself? Because obviously, maybe the majority of the decision will go against what you believe. So how do you ensure that it shows that you were not part of those decisions?
The minutes. So that's where 4 protects you. That's the business judgment rule. And as I mentioned, the court did take into account the business judgment rule before making its declaration. And 76.4 and 5 deal with the business judgment rule, and it sets out that you must take diligent informed about a matter. You must show you don't have a financial interest or material interest in the matter, and you have a rational basis for believing what you do, and that also relies on information prepared about others. So where all of this becomes evident is in the board pack and the minutes of the meeting. So where you can say that you had a rational basis for either your objection or your support for a decision will be evident by the minutes of the meeting. So the minutes of the meeting will show what you said, what your views were, whether in support of or against. Because as a board member, you're not expected to be supine. You're expected to be inquiring. You're expected to come into a board meeting and to probe and ask questions and to contribute to that. You are entitled to rely on information that's presented to you, but you must do so still with an inquiring mind. And you'll see from this matter that all the evidence that was given, so what you would do there is you would have what is called contemporaneous evidence to support what it is that you say in support of why you supported the decision or why you opposed the decision. And your contemporaneous evidence is your emails, your notes, your letters that you sent at the time. So, you know, the minutes of the meeting is one. During the minutes of the meeting will reflect that you noted for the record you don't support this particular decision. And it'll, you know, you will have emails saying, I'm referring to this and why are we doing that, etc., etc. So, which is exactly what happened in this matter. That's what they used as support, contemporaneous support for everything that they said, the letters that they sent, the emails that they sent. In addition, if you look at all the recent judgments that are coming out now, always where you have an institution being taken to court, you always have a case where the employees, the directors, etc., always have contemporaneous notes to support why they said they didn't support anything, and here's their contemporaneous notes and why they were in turn then moved out of the institution, so to speak. And there's a few recent ones, but I'm sorry that they just don't come to mind. So basically you do so by speaking up at the meetings and just noting it for the record, your objections, and you do so by sending emails and letters. Those are your contemporaneous notes to note your objections to any decisions and why. And when reasons are being presented for why decisions should be taken, you question them. You ask inquiring questions. There was a recent case now where the CFO had been fired. Yes, sorry, the SABC matter. She was the CFO for SABC, and she was fired because she had refused to approve bonuses and increases for the ex-CEO, Mr. what's his name, Schlaudi, etc. And she was eventually fired because then she took them to the CCMA. And in finding in her favor and giving her all her back pay, etc., the court went through all of this evidence and said it was clear that because she, in the meetings, questioned why these increases and these bonuses were being paid, etc., that's why she was ultimately disciplined and fired without reason. So yeah, it all eventually comes out.
Thank you.
Anybody else? So it's very easy to make sure you protect yourself. It's just simply read your board pack, with regards to the agenda for the meeting, what the issues are that are going to be discussed. Read the supporting documentation that's given to you in support of it. Apply your mind to it. Ask questions. The case law says you're not expected to be a subject matter expert. You just simply are expected to bring an inquiring mind to it. And that's the case law on the business judgment rule when using that to defend your actions. You simply meant to ask the right questions and to just question. You are entitled to rely on information. So if part of the board pack is you've been given the company's opinion by its legal advisors, you've been given an opinion by its accountants, the company secretary has given you an opinion, you're entitled to take into account what's been given you by the company employees and rely on that evidence, on that information that's been given to you. You're entitled to rely on the information that's been given to you in the board pack. But you're going to rely on it if you've read it. And if you're not happy with it, you are entitled to question it. You're entitled to get further information or ask for further information if you have questions. And you must just put all of that on the record at your meetings, particularly if you object to it. But you must have an inquiring mind, particularly if you do object to anything. Because ultimately you're there to act in the best interest of the company. First and foremost.
Hi, Trudie.
Hi, Kabasile.
Yes, I just want to find out how important is it the signature of the chairperson, for in the case of the Dudu Myeni case, if there were lots of objections raised in a particular matter, the MRS matter, and when the minutes were produced and she didn't sign, what are the implications?
What do you mean objections to the rephrase?
No, I'm trying to find out in a board meeting, you were indicating that if as a board member you are against or you want to raise the objection in a meeting, what happens, how important is the signing off of those minutes? Because the minutes are signed off also by the chairperson. What if the chairperson does not agree with that and they don't sign? What are the implications?
Oh, then you just simply send an email.
All right.
And I disagree with the minutes that have been sent to me. They're not a true reflection. And this is actually what it was. And in fact, that did come up in this matter as well, because as the chairperson is the person who's tasked with convening meetings, board meetings. So that's one of their tasks. And in one of the meetings that she had convened, there was no agenda, and she didn't really allow anyone else to take notes or to speak. And thereafter, she circulated a minute of that meeting in which she set out that in relation to the Airbus swap transaction, that it had been agreed by everyone at the meeting that they would renegotiate it. And the CFO, the ex-CFO, wrote back and said, no, that's not what was agreed, and that's not what was even discussed. So I object to that as being a minute of the meeting, because he immediately, the minute he left that meeting, because they weren't allowed to bring in papers and pens and take notes or anything, the minute he left, he quickly went and from his memory made a note of what had transpired in the meeting. But obviously that was a hot topic at the time, so they all knew what was agreed and not agreed. So he immediately sent an email saying that is not what was agreed, and I object to that being in the minute. So I don't agree to that. And one or two of the others who were also the plaintiff's witnesses also sent emails confirming that. So, and that their emails were used as contemporaneous evidence to support that. So it wasn't a case of she was able to put up a minute saying, but we all agreed, here's the minute, because they put up the email saying, no, that minute does not correctly reflect what actually was agreed at that meeting. So you need to be vigilant. When you get the minutes, you must read the minutes. And if they do concur with what was discussed and agreed, well then yes, at the next meeting you sign it off. But if they don't, then you don't. Your objection. So I don't agree to these aspects on agenda item 1, 5, and 7. They must be changed. And if they're not changed, you note your objection and leave your objection there. but you have your contemporaneous note. I hope that answers your question. So any other questions, concerns? I think, wait, I mean, as long as you go in there and just, you know, bring your A game, no reason why you shouldn't all be, or probably aren't all, currently amazing board members. I'm sure. So I see there's somebody else who's got a chat up. Oh, okay. So unless there's anything else, there's a comment here from Claire. It's just, oh, thank you. Yes, you need to be a strong voice in the book. But you don't necessarily need to be a strong voice. Sometimes you don't have to. Sometimes if the meeting is going well and everyone's in agreement and, you know, there's no need for you to be a strong voice. You need to always be prepared, but you don't necessarily always have to go into a meeting prepared to speak your mind and stand out. I mean, I think that's more the exception than the rule. But when it arises, you must be prepared to do that. So unless there are any other questions, then I think we'll close. So thank you everyone for joining us. I'm just having a look. No, they aren't.
Thank you.
Thank you.
Thank you. That was awesome. Thank you.
Pleasure.
Thank you, Trudie. That was awesome. Very, very informative.
Pleasure.